gonna slam this thing.
I don't know if I'm gonna slam it, it's a bunch of questions.
Okay. Good evening, and welcome to this public hearing of the Standing Committee on Social Development. My name is Jane Wayellen Armstrong, and I am the MLA for Mofi Culture Region and Chair of the Standing Committee. At this time, I will ask committee members to introduce themselves, starting to my left. Julie.
Julian Morse, MLA for Frame Lake and Yellowknife.
Good evening, I'm Shauna Morgan, MLA for Yellowknife North.
Hi there, welcome. Thanks for joining us. I'm Kate Reed. I'm the MLA for Great Slave.
Okay, and those online?
Good evening. My name is Cheryl Yaklai. I'm the member for the Det'anchogh.
Okay, thank you. Bill 49, Safer Communities and Neighborhoods Act, received second reading in the Legislative Assembly on June 2nd, 2026. Bill 49 would create a new way to deal with rental properties where people are continually disturbing or endangering their neighbors with illegal activities, where residents can make confidential complaint that a new scan team would investigate and take actions to resolve. This committee has been tasked with reviewing the bill to see if it needs any changes. If it has any issues we can solve, and if it is ready to continue on its path to becoming a law. This evening, committee will hear from the sponsor of the bill, the Honorable Minister of Justice. After that, we will open the floor to any members of the public here today who wish to share their feedback on Bill 49 with committee. At this time, I would like to turn the floor to the Honorable Minister of Justice. Please proceed with your presentation.
Thank you, Madam Chair, and thank you to committee for the opportunity to be here tonight. I am pleased to be here today to discuss Bill 49, the Safer Communities and Neighborhoods Act, or SCAN Act. The Act gives the GNWT the authority to establish new civil mechanisms to stop specific illegal activities that occur habitually in a rental premises and or threaten the safety of the neighborhood. The Act draws primarily from SCAN legislation in Yukon and Saskatchewan, but omitting the enforcement-heavy responsibilities of other jurisdictions that would be costlier to implement. The Act aligns with well-established NWT legislation, the Residential Tenancies Act, adding SCAN-specific pathways where tenants, their households, or visitors are involved in the specific use activities. The NWT approach is only just emerging in SCAN legislation in other jurisdictions, notably Saskatchewan. Although channeling SCAN matters through the rental office instead of the courts has been used in practice in jurisdictions including Yukon. Where a SCAN investigation indicates that property owners rather than tenants are involved in the illegal activities, the Act allows SCAN officers to disclose information and provide evidence to the RCMP and civil forfeiture authorities for civil forfeiture purposes. This bill represents one of three pieces of public safety legislation that the GNWT has committed to introducing during the 20th Legislative Assembly. Of the other two, the Trespass Act received assent in winter, and the civil forfeiture legislation is now a standing committee. Significant engagement was undertaken on both SCAN and civil forfeiture legislation in the fall of 2025 through in-person community meetings, virtual meetings, online surveys, and stakeholder and partner engagement. I have a short presentation and will outline a little bit more of the information on the proposed legislation, its purpose, and what it contains. And with me tonight, I have Brad Patzer, Assistant Deputy Minister, Attorney General, and Sabona Moyo, Legal Counsel for the Department of Justice. This concludes my opening remarks, and I'd be pleased to answer any questions you may have. Thank you, Madam Chair.
Okay, thank you, Minister. Proceed with your presentation.
Thank you, Madam Chair. I'll have a short introduction to the SCAN legislation in the presentation, some brief comments about the development of Bill 49, and then we'll get into some of the details and an overview of the legislation in the presentation. So SCAN, or the Safer Communities and Neighborhoods Act, will provide new civil mechanisms to stop specified illegal activities that occur habitually in rental premises and/or threaten the safety of a neighborhood. With the exception of Quebec and Nunavut, all jurisdictions in Canada have developed SCAN legislation. Newfoundland and BC passed their bills and their acts, but they never brought them into force, while the Ontario bill died on the order paper. The NWT first introduced SCAN legislation in 2007, but it did not pass. The new proposed NWT SCAN Act is based in part on current best practices from other jurisdictions like Yukon with shared northern circumstances, or like Saskatchewan with specific elements that work in the NWT context and scale. The bill proposes a unique made in the NWT SCAN system. The new approach will leverage existing dispute resolution mechanisms under the Residential Tenancies Act, as opposed to the approach taken by other jurisdictions that is enforcement focused. The NWT approach is meant to address some of the financial and personnel concerns that are associated with the enforcement approach that is common in heavy SCAN units in other jurisdictions that would be particularly challenging in the northern context. The development of Bill 49. The Department's policy work started with a jurisdictional scan of other Canadian jurisdictions that have SCAN legislation. From that, we identified Yukon and Saskatchewan as models we could learn from. We also informally engaged with the Yukon SCAN unit, and the department also participated in the 2024 SCAN National Conference, and now sits on the ad hoc provincial territorial SCAN calls that are hosted by Yukon. Following approval of the legislative proposal, we began public engagement. As the minister indicated, there was an online survey, there was online meetings, and several in-person meetings. The SCAN Act is structured into 5 parts. Part 1 sets out the introductory provisions, including definitions and appointment of SCAN staff. Part 2 addresses the collection, use, and disclosure of information. Part 3 outlines the SCAN complaints process. Part 4 establishes the rules for obtaining, varying, and appealing community safety orders. And Part 5 has some general statutory provisions. The department completed a consultation assessment and determined that the legislation itself, as a law of general application, did not trigger any consultation obligations. Although it is possible that certain SCAN actions may involve property subject to Aboriginal and treaty rights. In these circumstances, the GNWT may need to consult before proceeding with actions under the proposed bill. However, the proposed bill itself will not impact directly or indirectly Aboriginal and treaty rights. As noted earlier, the SCAN Act includes a definition section. Some of the key definitions include the term specified use, which is used to describe specific illegal activities at rental premises that can form the basis of a SCAN complaint. Some examples of which include use, consumption, selling, manufacturing of liquor, cannabis, intoxicating or controlled substances, and contravention of applicable territorial or federal legislation, sexual abuse or exploitation of a child or related activities, obtaining of sexual services or related activities, committing or promoting a criminal organization offense, accommodation, aid, or support to a gang or criminal organization. Complaint is another term that is defined, and it's defined to include confidential complaints made by members of the public and those initiated by the director of SCAN. Resident is defined to include others besides the tenant who live at the rental premises, who may be the subject of SCAN actions or may be impacted by SCAN actions. The other key definition is for community safety orders. These are remedial instruments issued by rental officers if there is a SCAN application. The definition also includes orders that vary or set aside an existing community safety order. In terms of interpretation, the Act provides clarity on what brings certain activities within the scope of SCAN. If the activity negatively affects health or security of someone or in the community, or if the activity interferes with the peaceful enjoyment of a property in a community, it will be within the scope of SCAN. Now, the SCAN unit will be led by a director. It's a statutorily appointed position under the legislation. The director may appoint investigators and contract investigators to perform duties under the Act. Ad hoc use of contract investigators may enhance the work of the SCAN team at busier times or when complaints arise in smaller communities. This also provides the flexibility to potentially hire investigators locally in small communities when a SCAN complaint arises. The director is also responsible for receiving and investigating complaints, as well as commencing, conducting, and discontinuing SCAN proceedings. Investigators will be required to submit a written report to the director when they complete an investigation. Part 2, Information and Records. In line with legislation in other communities, the Act allows for the mutual sharing of specific information and records with the RCMP, public bodies, local governments, including Indigenous governments and organizations, and others. The Act requires that any information gathered from or records created through investigation must be kept confidential, except to make an application for an order or an appeal under the Act, to prosecute an offense under the Criminal Code or another federal or territorial act, and for the purposes of an application or proceeding under the Civil Forfeiture Act. Part 3, Complaints. The Act requires that all complaints be kept strictly confidential. The identity of the complainant is not revealed, and the complainant is not required to be involved in any investigative or other proceedings that may follow from their complaint. The director may also initiate a complaint, and that complaint then follows the same process as those from members of the public. Once a complaint is made, the director has options. They may investigate the complaint, resolve the complaint by agreement or other informal action, send warning letters to tenants or other residents, dismiss an unfounded or frivolous complaint, or apply to a rental officer for a community safety order. The director must, without delay, notify Child and Family Services if there are children in the premises that is under a SCAN investigation or an application, and the director believes that the health, safety, or security of the children are at risk. Another notable item is that SCAN unit staff cannot be compelled to appear in court or other proceedings to provide information on the complainant or to provide evidence obtained on behalf of the director for SCAN purposes. In terms of the conduct of proceedings under the Act, there are some very straightforward provisions that clarify that the Supreme Court rules apply to all proceedings under the SCAN Act. During a proceeding, the director can refuse to disclose sensitive information, either in examination for discovery, in an affidavit, or at a hearing, if it is to protect the identity of a confidential informant, a person's safety, or a police investigation. Community safety orders. When the SCAN team applies for an order to a rental officer, the application must be served on all the other parties, which could include the tenant and the landlord. The factual allegations in the application are the results of the SCAN investigation, which may be different from the facts in the original complaint. Where an application for a community safety order must be heard on an urgent basis, the Act allows the rental officer to shorten the timelines for service within the Residential Tenancies Act timelines, subject to any procedural fairness owed to the parties involved. The Act sets out the remedies that the rental officer may include in a community safety order, such as to prohibit any tenant or other resident from contributing to or permitting the illegal activities, to require the tenant or other resident to vacate the premises, to terminate the tenancy agreement, to prohibit the tenant or other residents from re-entering or reoccupying the premises. Where a community safety order is in place that terminates a tenancy agreement, either the landlord or the director may apply for a separate order evicting the tenant if required. That is, if they don't leave voluntarily. The Act looks to protect vulnerable persons who may be impacted by any orders made by the rental officer. After an order has been made for a resident to vacate a rental premises, the director must determine whether the resident has alternative accommodation, and if not, the director must help in finding alternative accommodation that they think is reasonable. If the resident caused or contributed to the illegal activities, the director may help out, but is not required to do so. A resident or the director may apply for an order to be varied or set aside. If the resident applies, the rental officer must consider whether the resident caused or contributed to the illegal activities, whether the activities have ceased, and whether the resident or their household will suffer excessive hardship if the order is not varied or set aside. In varying or setting aside an order, the rental officer may fix a date for the resident's tenancy agreement to be terminated or the resident to vacate the rental premises, set aside the termination of the resident's tenancy agreement or reinstate the tenancy agreement if the date of the termination has already passed, set aside the requirement for the resident or a member of the resident's household to vacate the rental premises if they have not already vacated it, authorize the resident or a member of the resident's household to re-enter or reoccupy the premises or complex, or make any other provision the rental officer considers appropriate in the circumstances. Consistent with the Residential Tenancies Act, the legislation maintains the 14-day timeline to appeal a scan order from the date of service of the order. The legislation allows any party, the director, landlord, or a resident, to appeal a scan order or a rental officer decision under the SCAN Act, or apply to vary or set aside an order to a judge of the Supreme Court under Section 87 of the Residential Tenancies Act. Further appeals of a decision of an order of the judge of the Supreme Court may then be made to the Court of Appeal under Section 90 of the Residential Tenancies Act. Part 5, the general provisions. Subject to certain provisions, the Residential Tenancies Act and its regulations apply with necessary modifications to applications, appeals, and related decisions made under the Act. If there is a conflict between the SCAN and the Residential Tenancies Act, the SCAN has paramountcy. An applicant must file their application with the rental officer and serve a copy on the other parties in accordance with the Act. No legal action or proceeding can be initiated to challenge, prevent, or review a community safety order except through specified applications or appeals under the SCAN Act. The SCAN unit may request the assistance of the RCMP to carry out some of their duties under the Act where there might be safety concerns. The Act establishes that any contravention of the Act or future regulations constitute an offense with fines and/or imprisonment according to whether the offense is a first offense and whether it was committed by an individual or corporation. Fines range from $5,000 to $50,000, and imprisonment for individuals only is for a maximum of 1 year. Evidence based on information and belief is allowed in applications under this Act without needing to identify the source or explain the basis for the belief. A person is presumed to be a part of a criminal organization if they've been convicted of such an offense, unless proven otherwise. Proof of conviction, a finding of guilt, or a finding of not criminally responsible confirms the offense, while charges that were withdrawn, stayed, or resulted in acquittal are not considered relevant. The Act has a 2-year limitation for the prosecution of any contravention under the Act. The Act also contains a provision that provides that SCAN unit members are not liable for any actions done in good faith. The legislation also requires the director to prepare an annual report that is submitted to the minister for tabling in the Legislative Assembly. The report must contain the following metrics and information: the number of complaints received, the number of investigations commenced and concluded, types of specified uses in respect of which an investigation was conducted, the number of warning letters sent, the number of complaints resolved by agreement or informal action, the number of applications for a community safety order and the number of community safety orders made, the number of children who reside or at the time resided in rental premises subject of an investigation or community safety order or an order evicting a tenant made on the basis of a community safety order, and any other information the minister may require. The Act also establishes regulation-making authority for a number of areas under the SCAN Act. And finally, the Act includes a number of consequential amendments to the Residential Tenancies Act for SCAN purposes to provide for clarity for readers. And that concludes the presentation. Thank you, Madam Chair.
Thank you. Thank you, Minister. Committee, are there any other questions? Are there any questions? Okay, okay, so who do we start with? Okay, we'll start with MLA Reid.
Thank you, Madam Chair. Thanks very much for coming here tonight and walking us through the bill. I've got quite a lot of questions, and maybe it's just, most of them are actually just based in clarity in my understanding of the bill itself. So I realize this is kind of in the weeds, but in the specified use, so that definition in the bill is applicable to someone who would be making a complaint as well as the community safety orders, if I'm understanding your presentation properly. And as I look through the bill and I look at the various specified use definitions, it goes through quite a lot. It's mostly around liquor, drug use, sexual exploitation and sexual services, criminal organizations. At the very end of the definition on specified use, it says any other use prescribed as a specified use, which I kind of interpret as a catch-all. So is it then the staff in the scan unit's responsibility to understand the flexibility of what to decide what could be a specified use within the definitions that you've given us in the presentation around a serious or immediate threat to health, safety, security, that sort of thing? Like, why is there that sort of like, oh, and if we forgot one, here it is in the definition? Thank you, Madam Chair.
Minister?
Thank you. I'll pass to Assistant Deputy Minister Patzer, please, Madam Chair. Thank
Mr.
you.
Blatcher?
Thank you, Madam Chair. Typically, when we have the term prescribed in the legislation, it's referring to the fact that there's probably going to be regulations. So there's a regulation making power under whatever section is 46, I believe, and prescribing any matter or thing required or authorized by this act to be prescribed. So if, as you said, if there is something that is missed, then rather than amending the act itself, it could be included in a regulation.
Okay. MLA Reid, do you have a follow-up question?
I do, thank you, Madam Chair. So on slide 6, and again, this is more of a sort of granular question about the bill itself. You speak about Aboriginal and treaty rights. If you say if it's possible that certain scan actions could involve property subject to Aboriginal and treaty rights, and in those circumstances, the GNWT may need to consult before proceeding with actions under the proposed bill. So I guess my question would be, how would you effectively complete a duty to consult in Section 35 rights in a time-sensitive fashion? Thank you, Madam Chair.
Thank you. Minister?
Thank you to Assistant Deputy Minister Patzer.
Yes.
Chair.
Please proceed, Mr. Patcher.
Thank you, Madam Chair. It's an excellent question, and you're right. In circumstances where there's an investigation ongoing and for whatever reason rights or Aboriginal treaty rights involved, it could be a difficult time to consult. I'm not sure that particular provision was actually meant to capture circumstances where there is an active investigation or whether perhaps an Indigenous organization has completed a project that involves some kind of right that might attract in a circumstance like this. I don't know if Sabona, in your experience, there was any Aboriginal treaty rights that might have been impacted in other jurisdictions, Madam Chair.
Yes, Ms. Moyo?
Thank you. No, I think the contemplation there was that if by chance in a scan there's something that comes up in our interactions with scan applications, and we see some kind of pattern where there's an impact on treaty rights that we did not contemplate, we would then proceed to engage. It wouldn't be something that we would do as once-offs when there's an active investigation. It would be something where once we recognize that there was something that we didn't contemplate when we were drafting the legislation, we would go back and say, okay, now there's an issue here, let's begin engaging.
Okay, thank you. MLA Yakalaya, do you have a question?
Yes, I do. What have you heard from Indigenous governments about the scan legislation? That's one question. Thank you.
Minister?
Thank you, Madam Chair. So, Madam Chair, we have had a lot of very passionate feedback from Indigenous communities. I was in Fort Good Hope last week with the commander of the RCMP for a community safety meeting, and I had leaders in that community come to me and said, if you need a letter of support for SCAN, I'll write it for you now. So there's a lot of interest and a lot of support. I mean, having said that, obviously, there's a lot of work for us to do here. Committee has work to do. Maybe I can just provide a little bit of context around that statement in that, during the community meetings that I've gone to, and I've gone to a number of really small communities to talk about community safety. And a lot of the communities are desperate for support, for some help. Drugs are destroying their communities, they're destroying their families, and they're destroying their young people. And so it's heartbreaking, really, to sit there and listen to, I'll give an example. A father was brave enough to share his experience in the public meeting about his 2 adult children that are heavily addicted in the life, and he's tried many things to support them, to try and get them out of the life, but he's desperate. He doesn't know what to do. The elders don't know what to do. The leadership is asking for help. I've been to, like I said, many small communities. The larger centers are a little bit different, but the small communities, you can truly see the direct impact and the fact that the leaders are looking for something. They need help. And I think we all can agree here that the solution is not enforcement. The RCMP are doing the job that they have to do to deal with drugs and crime, but it's a whole of government approach and a whole community approach that includes families, leadership at the community level, at the territorial level, at the federal level, all the other departments, health, social services, housing, et cetera. We all have to work together to try and solve this problem. This is a tool that we want to bring forward to help to address some of the immediate concerns that are really impacting the small communities. Thank you, Madam Chair.
Thank you. MLA Yakalaya, do you have a follow-up question?
Yes, I do. My next question is, first of all, thank you for the presentation. So now we'll go into the question. What are the minister's thoughts on how this legislation might affect people experiencing homelessness in the NWT? For example, by inadvertently increasing our unhoused population through eviction orders. Thank you.
Thank you. Minister?
Thank you, Madam Chair. Madam Chair, I believe that within the legislation, there are some safeguards to help address the potential of someone being evicted from their home. And we intentionally looked at our Made in the North version of the SCAN legislation to be different than what was introduced in many southern jurisdictions where it was more of an enforcement wing. This is an investigation tool that will allow us to address the activities that's happening in these residences. And part of that, from the conversations I've had and from what I see in the communities and what I hear from communities members, is that there are crack houses, there are drug houses, there are guns, there are violence, there's teenage girls entering prostitution. And in many of these circumstances, there are also children in those homes. So this is a tool that helps to identify those concerns, address those concerns, and we have many, many tools within our toolkit to help assist any people that would be inadvertently impacted from this legislation being enacted in what it's intended for, which is to disrupt the illegal activity. It's not intended to impact vulnerable people. We want to make sure that we're supporting those vulnerable people through the provisions that we've put in the Act, the work that committee will do, and how we will look at, ensuring that we have a all-of-government approach. Thank you, Madam Chair.
Thank you. MLA Morse, do you have a question?
Yeah, I have a number. Thank you, Madam Chair. I have a few that are just about the specifics in the Act itself, and then some more general questions for the Minister as well. So the first one is one that stood out to me just reading the Act, and that is in a couple of places under specified use, and just for people watching, specified use in quotes is a defined term under the Act, and those are the activities that could get you evicted under the Act. So I would note that in a couple of cases, use of substances such as cannabis, alcohol, or intoxicating substances as written in the Act could result in eviction. And that kind of gave me pause, although I note that in the case of alcohol and cannabis, it says in contravention of those acts. That's not the case for the intoxicating substances. So what's not really clear to me, though, to get to the point is, so is using an intoxicating substance inherently illegal? And I guess what I'm really getting at here is, let's say somebody's, I don't know, using a drug in their home, such as alcohol, cannabis. These are things that people can legally obtain in stores in the NWT from local businesses. There's nothing illegal about using them. So can you help us understand how people engaging in legal activities would be protected by this act, or help us better understand how engaging in a legal activity in your home couldn't be grounds for getting evicted here? Because the bar is quite low in terms of anybody could just suggest that you've been doing this in your home, and next thing you know, an investigation takes place, and we'll get into that in a bit. But I am curious about the use, because I was under the impression when I first heard of SCAN that we were talking about people dealing drugs, committing, very specific illegal activities. But in some cases, it seems like we're walking the line of activities which may or may not actually even be illegal. So can you help clarify that part of the Act, the specified use definitions? Thanks.
Minister?
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patzer.
Okay, Mr. Patzer?
Thank you for the question. It's a good question. The intoxicating substance, in my interpretation of the definition in section D of the definition, is general, and it doesn't, it refers to, in my mind, it refers to substances that aren't caught by the Liquor Act, that aren't caught by the Cannabis Products Act, but still are intoxicating in nature. And we all know there's a lot of different types of drugs and substances out there that will intoxicate a person. So it's meant to be more of a catch-all and not refer to liquor and not refer to cannabis, because those are specifically mentioned in subsection A, subsection B, and C, as you noted.
Thank you. MLA Morris, do you have a follow-up question?
Thank you, Madam Chair. Well, I hope we get a couple of chances to do follow-ups, because I'm going to have a few, because I have a follow-up just for that one. So the thing that I'm trying to get clear about, though, is using an intoxicating substance, like, for example, I'm just looking at them. I mean, I want to be clear, I'm not suggesting that it's a good thing that people go around sniffing the various distillates or products containing petroleum distillates, all the listed items. Obviously, we don't want people getting into this stuff, but it's not technically illegal for that to be taking place, right? So what I'm trying to get at here is, can people actually be evicted under this act for committing legal acts within their home? How do we reconcile that with, I guess, a reasonable application of the law by courts? I mean, if a person is not breaking the law in their home and then they're evicted for that, it strikes me as some form of, I guess, what maybe to ask the question in a more legal form. I mean, does the minister believe that a provision such as that might be open to constitutional challenge?
Minister of Justice?
Thank you, Madam Chair. I can't provide a legal opinion as to whether that is constitutional or not. What I can say is the intent of the act is about activity that is harmful to the community. So it's not necessarily focused on one individual sitting in their living room in their home by themselves, right? Its intent is broader than that, and it's about the bigger picture. And I think that I think we could look at any piece of legislation and we could, get down to that level of detail to say that you could pull out essentially any piece and say that, well, in this circumstance, it could be this. But that's not really the intent, as we're looking at it more broadly as a piece of community safety legislation that's targeted at the broader safety of the community. Thank you, Madam Chair.
Thank you. MLA Morgan?
Yes, thank you, Madam Chair. I also have a number of questions about this, but I'll start with just asking for some more clarification, because I do keep hearing the minister say that we know that enforcement per se is not the answer, that this act is intended to be an investigation tool and it's to disrupt activity. But my understanding is that the whole point of the act is to allow us to more easily evict people, which is a form of enforcement in my head. Like the example that was given, that I do understand that people are desperate for change, they're desperate for help, but in the example that was given, someone who has adult children who are involved in the drug trade, addicted, I am failing to understand how it's going to help them. It will evict them, but then what? Like, I don't see the then what, how this is going to I mean, those people are still going to be there, probably in the community. I'm not sure where exactly. They're not going to be suddenly less addicted. Like, how does it, in that scenario, how would it help those adult children that folks are so concerned about, or actually disrupt the drug trade? I wonder if the minister can clarify. Thank you.
Minister?
Thank you, Madam Chair. Madam Chair, the intent here is not to evict the addicted person that is caught up in this lifestyle. It's to addict the people that are supplying the illegal narcotics, that are going into communities, that end up, hooking up with local people, using their home as a distribution center for drugs. It's to disrupt that activity. That's the intent of this. It's not intended at the person that's caught up in the addiction, is not the target here. The target is to disrupt the trade, to make it more difficult for people to come into the community, to take advantage of local people, to end up inside of a home, working with that person. And we hear all the time that, I hear it from many leaders, they could drive down the street and they can point out the homes to you where the drugs are being sold. But there's no tool that allows, in the current toolbox, that allows that to be dealt with. This is a tool that will assist in that, with a process that will identify that activity and have a tool through our current system through the rental officer to be able to evict that person that is participating in that illegal activity, which is having a negative impact on the whole community. Thank you, Madam Chair.
Thank you. MLA Morgan?
Thank you, Madam Chair. Okay, so I can see a particular scenario, which is the one that people do emphasize more, the idea that someone from the outside, ideally in people's minds outside the territory, is the one physically, bringing the drugs into the community, staying there, and if we just get that person out, then we'll uproot the problem. It doesn't exactly deal with the scenario of if there's someone, a member of the community, that is the one bringing the drugs in and selling out of their own house or rental unit. But anyway, I'll set that aside for a second. I know that you've said that the order, the rental officer has to consider, for example, whether there are children residing in the premises. So after they consider that, then what? So does that mean that if there are children in the premises, then they would decide not to evict, or they would simply, send a CFS worker over and hope for the best, or is there any sort of like procedures laid out for what is supposed to happen in that case? Like, what does it mean that they just have to consider it? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. It says in section 13, the director shall without delay notify the Director of Child and Family Services appointed under the subsection 51(1) of the Child and Family Services Act if the director has reason to believe that there are children residing in a rental premises that is a subject of an investigation or application under the Act. So the intent is that the director would inform Child and Family Services, and the responsibility to address the issue with the children would then fall with Child and Family Services. If I may, Madam Chair.
Yes, thank you.
Yeah, so, and I mean, from my visits to the community, this is certainly one of my huge concerns that I have as minister, is that there are many, many children that are impacted in this activity in the communities. Many of these homes that have this activity going on also have children residing in them. And maybe just to the point that you raised afterwards, MLA Morgan, was that this is not just people from the outside that are doing this. There are community members that are doing this without assistance from the outside, other than that the drugs come from somewhere. So it's not just people from down south. It's not just people, you know, organized crime members. There are northern people that are engaged fully in this activity all across our territory. So, you know, I think we need to really open our eyes to that fact that this is not just an external problem. This is also an internal problem. Thank you, Madam Chair.
Thank you. I do have a question as well. I know that in small communities, in some small communities, you know, there's some families with children that I know that were evicted and moving back into overcrowded house. Yeah, so that is a major problems, and or children become ward of the state. So in many cases, I think that's what it's happening in many of the small communities, because we don't have enough foster parent, so they either go to larger regional center. So with that in mind, in your report, you did mention about, about second chance. Well, it's not about second chance, but checking with them to see if they have an alternative accommodation. So, do you guys give? Is there in the bill where it says what do you do with families with children, especially, whether they're two-parent and or single parent, they have small children in the house? Are they given the same choice? Thank you.
Thank you, Madam Chair. Madam Chair, in the Act, it does say that the director shall make reasonable efforts to determine whether a resident or residence or rental premises who is required to vacate the rental premises as a result of the community safety order has alternative accommodations. So that is part of the Act, and I think that the other piece that we have to consider here is that as we address the drug epidemic across the NWT, it's also an all-of-government approach to this, right? Like, there are other departments, the Department of Housing, Health and Social Services. It's not a one-dimensional approach where it's just about, kicking people out of a residence and not considering the subsequent impacts to others that are essentially vulnerable people in this scenario, right? So we have to, I think, look at this very broadly, because I firmly believe, my personal belief is that there's also a tremendous impact to that potential spouse or those children from remaining in that home with that activity going on. So, you know, I see it as a lose-lose, really, if you have that type of a scenario where it's going to have a negative impact no matter which way you go. But I firmly believe that we have to address the drug problem. We have to address the people that are doing this illegal activity. But at the same time, we have to have those supports in place to support the people that could potentially be impacted by this as we move forward. Thank you, Madam Chair.
Okay. Thank you. So if this Bill 49 goes into force, so what is the expected annual budget? And if these, the investigators and contract investigators, will they be located in each region? There's 5 regions. Hopefully there's going to be 6 regions with Det'anchogh. So I just wanted to know if we're going to have people in each region to deal with the complaint. Thank you.
Thank you, Madam Chair. Madam Chair, that would be in the implementation phase, and we haven't quite got to that point yet. We need to get through, once the bill is passed, the regulations will be developed, and then we will look at implementation, and all 3 of the pieces of legislation work together. So again, that would be looking at how the implementation would roll out for all 3 pieces. Thank you, Madam Chair.
Thank you. Thank you, Minister. So we have time for second set of questions. So I'll go to MLA Reid, and you can ask 2 questions. And then I'll go to MLA Morse.
Thank you so much, Madam Chair. You know, I'm really struck by this conversation and your comments, the minister's comments. It feels like this act is both being perceived as a scalpel and a sledgehammer, and it's funny. It's just really interesting to listen to the discourse. So I just wanted to make that comment. But I do have a specific question that it builds on MLA Akalaya's question around homelessness. So in the bill, it talks about making sure that the director can propose alternate accommodation for people who are evicted or getting out of the housing situation. But specifically, it also notes, I'm so sorry, I'm trying to move through pages. There's many bits and bobs in this act I want to make sure I'm getting right. So specifically, there is an exception, however, that if the director reasonably believes that the resident caused or contributed to the activities that are under the order, they're not obligated to provide assistance. So when you say that you're doing your best to make sure that people are not made homeless, there are very clearly exceptions in the bill that could result in homelessness. And I recognize that this person that is this amorphous person in the director's mind might be the person causing the problems, but how is that not a charter issue? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I'm sorry, but I can't give a legal opinion on a charter issue. Thank you, Madam Chair.
Okay. MLA Reid, do you have a follow-up question?
I have a different question, I guess, if that question is not going to be answered. So in the bill, it also states that if the SCAN Act or the following regulations, if the act is passed, are inconsistent or in conflict with a provision of the Residential Tenancies Act, then the SCAN Act would prevail. So my question is, how does this ensure that tenants' rights and protections under the Residential Tenancies Act are not inadvertently diminished as a result of this proposed provision? Thank you.
Thank you. Minister?
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patzer.
Mr. Patzer?
Thank you. The SCAN Act is obviously very specific to the community safety orders and the processes and the thresholds under that particular piece of legislation. So with respect to the procedural rights under the Residential Tenancies Act, I don't see a conflict between this particular SCAN legislation and the Residential Tenancies Act. So I don't think there's going to be any problems in terms of meshing the two processes. I take it your question was more towards the rights, which I see more as a procedural type of issue rather than a different type of issue, but I wasn't clear. Thank you, Madam Chair.
Thank you. Now I'll go to MLA Morse.
Thank you, Madam Chair. My next question is about something that I noted isn't defined and seems to have some fairly large implications, or could. Section 12E of the Act, I'm not sure it's section, subsection, I've forgotten about all that stuff since I last worked in a legislative role, but the post a community safety warning in accordance with any regulations. What is a community safety warning? It is not defined in the Act. And I'm taking, my interpretation of a community safety warning is the director goes out and posts on a community board, this house is conducting activities in contravention with the Act and we want you to know. But that, again, I get back into, I'm not going to ask you to opine on constitutionality because I know you won't. But again, could a person's rights be seen to have been infringed if, I mean, it's worth noting again here that they may not have actually broken any laws. They may not have actually done the things that they're being accused of. And so the director is going to have the power to just go and post in the community a warning to the community. Can you help us understand what that's going to look like and how it's going to work?
Minister?
Thank you, Madam Chair. I'll pass that to Ms. Moyo, please. Thank you, Madam Chair.
Ms. Moyo?
Thank you, Madam Chair. I think this specific 12(1)E is read in context with what comes before it, which is the attempt to resolve the complaint by agreement or informal action. So it's some of the informal type processes the director can leverage to be able to address some issues. Say it's a complex and there's a concern with people smoking cannabis or trading weed in the parking lot, for example. So the director can try and resolve that by posting a warning that says, please refrain from doing XYZ activity. It's not going to infringe on the privacy of specific individuals. It would be a way of trying to herd the problem before it becomes out of control, as it were. So it's the design of the Act is to try and leverage various informal type processes, resolutions, before it gets to actual official mechanisms. I hope that answers the question.
Okay. Thank you. MLA Morse, you have a follow-up question?
Thank you. That answers the question. Well, I guess what I'm wondering is where is that explicit in the Act? And I'm just going to expand that question because I had one on the minister's last reply as well, that's what a community safety warning means. Because I think it's not clear to me that doesn't mean that the director would be warning people about the house in question. And I think if it's clear when you say it, but if it's not clear in the Act, then I think that's the issue, right? So the other one is, the minister was clear that the intent of the Act is not to evict people who are suffering from addictions. The whole point here is to target drug dealers. But again, that's, at least at my first reading of it, not clear in the Act, because the Act is quite specific that drug use is a contravention, which can be used as a reason to evict a person. So the minister is saying the intent of the Act is not to target people who are experiencing addictions. But the Act itself is very explicit that it is. And so I'm finding the messaging about what we're trying to address and the problems we're trying to solve feel contradictory in my reading of the Act, and I'm just trying to reconcile that and understand how is the Act making the things that the minister and his staff are saying explicit within the legislation itself. Thank you.
Minister?
Thank you, Madam Chair. Perhaps I was not clear in how I said what I intended to say was that the intent is not to go specifically after vulnerable people because they're addicted or in the lifestyle. It's more broadly about the issue of the illegal activity. You know, I want to make sure I say this carefully. I don't want to say this in an offensive way, but the folks that are caught up in this are not are part of what comes out of this tremendous issue that we're facing. Right? Like the people that are addicted, that are caught up in this lifestyle, they're a result of the criminal activity that's happening. So I don't know if I was just, that wasn't how I intended when I first said that, was that, you know, this is about addressing the criminal activity, and I want to make sure I refrain from.
We can also say that it has to meet this threshold before the act is engaged.
So maybe, I'll go back to the act. So for the purpose of the act, this is the threshold it has to meet. A community or neighborhood is adversely affected by the activities if the activities affect negatively the health, safety, or security of one or more person in the community or neighborhood, or interfere with the peaceful enjoyment of one or more properties in the community or neighborhood, regardless of whether the property is privately or publicly owned. So maybe that just focuses the intent a little more directly at the act, and as opposed to my more broad statement as my personal interpretation. Thank you, Madam Chair.
You okay?
Well, I would have. Thank you,
You wanna
Madam
reply?
Chair. Yeah, just to be clear, I just wanted to ensure that we had clarity if on just the specifics of my question, the community safety warning. I had asked, where is it made explicit in the act? And I appreciate the minister was trying to clarify what he said, and that's fair. But I was looking for places where the act is specific about what the use is. So the minister was saying, and how you were wording it is less of a concern to me than how the act is wording it, is just the posted community safety warning. Where is it explicit that that is not intended to be kind of a warning to the community about somebody's property? And the other one was just about how the act is explicit that the purpose of the act is to, I guess, if I can make this even more simple, why is the act not just specifically targeting drug dealers as opposed to having this expansive list of uses of drugs, which of course would necessarily target addicts themselves as opposed to the dealers? Thank you.
Minister?
Thank you, Madam Chair. So maybe I will go to Ms. Moyo for the first part of the question, then I will attempt to answer the second part
Okay.
of the question.
Ms. Moy?
So I think if you read the rest of that, it says in accordance with any regulations. So we will be getting into some of the weeds of the legislation in the regulations. The act tends to be more of a framework, and then as we go through, we then build into the framework the more nitty-gritty nuts and bolts aspects in the regulations. So it's going to go in the regulations. As well, the director will have a lot of quite a bit of discretion, especially in working with the communities to see what works well for that specific community, because we don't want to have perhaps a one-size-fits-all for everywhere. What might work in the Bodell might not work in, Fort Simpson. So there's that type of consideration that's being built into how the act is being structured at this point.
Okay. Thank you. MLA Akalaya, do you have a question? Oh, okay.
Yes, I do.
Minister, wait, Cheryl. Minister is going to reply to MLA Moore's question.
Just to the second part of the question, there are also consumption sites, so drug houses, if you will, that aren't necessarily where the drug dealers are selling from. So that's part of the intent as well, is to look at it a little bit more broadly, because that also can have a very negative impact on a community or a neighborhood or a neighbor, et cetera. Thank you, Madam Chair.
Thank you. MLA Yakalai, go ahead.
Yes, thank you. Thank you, Madam Chair. My question is, how will this work on the Hay River, like the reserve? Thank you.
Thank you. Minister?
Thank you, Madam Chair. It would be the same. It's a law of general application. Thank you, Madam Chair.
MLA Yakalai, do you have a follow-up question?
Yes, my next question has a couple of questions in there, but committee notes that a SCAN Act was proposed by the GNWT in 2007, but subsequently died at the committee review stage. MLAs at the time felt that the civil legislation could be abused to settle scores. Committee also notes that in Bill 49, the director may decide not to act or continue acting on a complaint and dismiss the complaint if they are in the opinion that the complaint is trivial, frivolous, or vexatious. What are some examples of evidence that would show the director that a complaint is trivial, frivolous, or vexatious? And if the director is based in Yellowknife, for example, how will they know if a complaint coming from another community is trivial, frivolous, or vexatious? And what other safeguards are in place to address this significant concern about this type of legislation? And were there any other lessons learned from the 2007 proposed SCAN legislation? Thank you.
Thank you. Minister?
Thank you, Madam Chair. Madam Chair, maybe I'll answer the very end of that, and in that I have not seen the 2007 legislation. That was quite a number of assemblies back, and so I don't know if what that piece of legislation looks like compared to our current modern-day NWT version of the SCAN Act. But I will pass to Assistant Deputy Minister Patzer for the remainder of the question. Thank you, Madam Chair.
Mr. Patzer, please proceed.
Thank you, Madam Chair. I believe the question is, how will the director know when a complaint is frivolous or vexatious? Typically, if something is frivolous or vexatious that comes across the director's desk, it's going to have a big red question mark or red flag on it. And it will either be obvious on the surface that this is just a neighbor complaining about another neighbor, or if the director decides to scratch the surface and make a phone call, do a very brief investigation, it will become obvious to the director that this is not a legitimate complaint. And those are the type of things that frivolous and vexatious tend to capture. The other aspect of the question is, how is the director going to tackle these frivolous and vexatious type of complaints if they're in a community where the director is not? And I think that's the solution we proposed in the bill, was to give the director the ability to hire investigators in the community, so that if there is a complaint and the director is either not traveling there themselves, there will be an ability to retain an investigator to do that investigation, to scratch the surface, to determine whether a complaint is actually frivolous or vexatious, or whether there's actually some legitimacy to it. Thank you, Madam Chair.
Thank you. MLA Yakalai, do you have a follow-up question?
That was my second question.
Oh, okay, I do apologize. MLA Morgan?
Thank you, Madam Chair. Okay, so I wanted to delve a bit into the appeal process. So if someone feels like, say, an eviction order or a SCAN order has unfairly targeted them, or has the wrong information, the wrong idea, the legislation does allow someone to, I think within 14 days, they can appeal to the Supreme Court judge, is my understanding. I'm wondering though, part of the point of this act is that it doesn't require evidence to the same degree as say the RCMP would require evidence in, seeking a criminal conviction, say. And also, we know that in this case, complaints can be anonymous, or, that whoever's making the complaint or bringing forward the information, they don't have to be upfront, or it's not revealed, certainly to the person who's being accused, who was the person who complained, or what was the basis. And in fact, it says explicitly that under the Act, evidence that's based simply on belief is allowed. So someone doesn't have to identify the source of the information or explain the basis for the belief, just that they believe someone is doing this thing. That's not allowed. And so how can someone mount an effective defense if they want to appeal this to the Supreme Court, but they're facing, accusations that are really vague or not substantiated, or it's just based on someone's belief? On the one hand, how are they supposed to effectively defend themselves against that? But then I guess on the other hand, perhaps a judge would then, always, I'm not sure how it would work, but maybe that would mean they would be more likely to side with the person who's appealing, going, well, there's this evidence is only based on belief, so therefore, they're going to allow the appeal. So, like, how does it work when, the evidence required at first doesn't have to be based on the kinds of standards of evidence we're used to with, the RCMP requiring. But then again, when someone appeals, they go to the Supreme Court. So at that point, are, higher standards of evidence required, either to accuse the person or for that person to be able to defend themselves? I wonder if you can explain. Thank you.
Minister?
Thank you, Madam Chair. I'll pass to Ms. Moyo.
Okay, Ms. Moy?
Thank you, Madam Chair. So the idea is that the part about the evidence being based on a belief is at the first level. So it would be if you're putting forward the complaint to the director, for example. The director does not take that as concrete and then proceed to apply for an eviction. What the director does is they do an investigation. If they determine that it is not substantiated, they dismiss. If the investigation uncovers actual evidence, that is the basis of the application for the director to put before the rental office. They will never go to a rental office based on someone's belief. The belief is just to initiate the complaint. Once they get to the rental office, the director must provide the rental officer with actual evidence. And at that point, the rental officer has the discretion to then assess that evidence and decide whether or not it's substantive enough for them to issue a community safety order. And a person's first level of appeal isn't to the Supreme Court. It would first start at the rental office. That's where they first mount their defense. It would be at the rental office. And the rental office has the opportunity to review the initial application and the initial order that was put forward. At that point, they can then vary the order, or they can choose to withdraw the order. If the person is then unhappy with what comes out at that level, that's when they proceed to the Supreme Court, at which point there is now sufficient body of evidence to be presented to a judge. So it wouldn't be, at that point, hearsay wouldn't be put before a Supreme Court judge. I hope that was helpful. Thank you.
MLA Morgan, do you have a follow-up question?
Thank you, Madam Chair. So that does help clarify some things, but my next question is then, are there certain standards of evidence collection or information collection that are going to be followed by the investigators? I assume they're not going to be required to follow the same kinds of standards that the RCMP has to follow, that's the whole point of this. I understand the Act gets into sort of the required qualifications of, say, an investigator, or that could be in the regulations. But aside from the qualifications of the person investigating, are there set standards of evidence collection or information collection that are going to be laid out somewhere that would then later on ensure that it's, for example, admissible evidence into a court if it comes to that, if there's an appeal to a court? You know, courts, I gather, have some standards of what's admissible or not admissible evidence, and if everything you've gathered is not admissible, then what's the point at that stage? And also, so, you know, the information collection needs to be eventually admissible evidence, but also how do you ensure that it's not just a violation of privacy? If it's not the RCMP, it's just some investigator out there that is gathering all kinds of information about someone. At what point does that become a violation of privacy, and how are those safeguards laid out in the Act? Thank you, Madam Chair.
Okay, thank you. Minister?
Thank you, Madam Chair. I'll pass to Ms. Moyo.
Ms. Moy?
Thank you, Madam Chair. We would follow similar standards as to other regulatory type legislative schemes. So we have wildlife officers, we have officers who do, you know, inspections for liquor. It's going to follow those types of standards. We haven't fleshed out what that's going to specifically look like. It's going to be forthcoming in the regulations, but it would be more on a standard of generally something like a balance of probabilities. So there would be standards on the type of information that's collected, how the information is collected, but it would follow, you know, just the types of other regulatory schemes that we have out there. We have precedents for that, so it wouldn't be. It's just an administrative process, and it follows, you know, procedural fairness, and there will be built-in standards for collection, use, and disclosure of information and the protection of people's privacy. All of that as is consistent with other types of administrative processes. Thank you.
Okay. Thank you. I do have one too. You know, living in small communities, and, you know, you see a lot of social media posts about drug house, and, you know, sometimes, well, you know, I know this bill is for public and private rentals. Then they know what to do, you know, like some of them. I know it's being reported, but the drug house, this is where a lot of people are asking too, is that they know who are the drug dealers in the community, but when they're living in their own house, private homeowners, they keep reporting, they keep saying, you know, the person's name, but nothing is being done. So I'm just wondering, like, how can we use this bill to target the private homeowners who are drug dealers? Thank you. Minister?
Thank you, Madam Chair. Madam Chair, in that instance, this bill wouldn't apply. So it would be, you know, information to the RCMP, but the Civil Forfeiture Act could apply in that type of an instance. Thank you, Madam Chair.
Well, that's, okay, thank you. That's good information to know, because I think that's what, you know, it was communicated with some of them on this. So thank you, and then I will go, we still have time for the third round of questions. So I'll go to Ms. MLA Reid, and then to Mr. Morris, and to Ms. Yakalaya. So MLA Reid.
Thank you
Please.
so much, Madam Chair. I really appreciate that we have so much time with a small group. I'm not going to ask you to provide legal interpretation. I'm going to walk the line away from that. In the bill, it's going back to the same question, but it's going in a different direction. So if the director, and sort of building on Emily Morgan's question, which is how far will the director then go to determine if a person does not have alternative accommodation, to provide assistance in finding that alternative accommodation if they're required to vacate due to a community safety order. And will this apply to every resident that is needed to vacate, and why? And I'll just leave it there. Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. Yes, Madam Chair, in the Act, it does say that the Director will make reasonable efforts to address all impacted individuals. Thank you, Madam Chair.
MLA Reid, do you have a follow-up?
Yes, thank you, Madam Chair. What is reasonable, I guess, is the best question I have, and I realize that that is maybe an interpretation question, so maybe if that one isn't answerable, why would this not apply to a resident that might have caused or contributed to the activities outlined in such a community safety order? Thank you.
Thank you. Minister?
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patson.
Thank you. As the minister indicated, sorry, Madam Chair.
Okay.
Yeah. Thank you. Madam Chair, as the minister indicated, the Act requires the director, as you point out, to make reasonable efforts. It also, in subsection 2 of section 18, it says the director, if the director determines that a resident referred to in subsection does not have reasonable alternative accommodations, the director shall provide assistance in finding accommodations. And to your last question about why is there, I guess, a bit of an escape hatch for the director, they're not required to do so if the person was, I guess, the cause of the community safety order in the first place. And I think it's just if the person is that bad of an apple, I guess the director does have an out in terms of not helping them find alternative accommodations.
Okay. Thank you. MLA Morris?
Thank you, Madam Chair. Yeah, I think that it's pretty clear from the communications the minister's sharing with us here and is shared on the floor and presenting the Act, is that the justification for bringing this forward is to address the drug crime and various issues that he's raised, and I won't repeat what he said, but what I'm wondering is, in my I was going to say scan of the legislation, but I'm not meaning to make a pun here. But in my research on scan legislation in other jurisdictions, the stats that they collected really focused on the number of evictions that were done, whether evictions were done, actions taken under the Act, and what I wasn't able to find was any evidence showing that those actions resulted in reduced addictions or drug crime. So I'm wondering if the department has access to information that I wouldn't, showing evidence that being evicted from a home helps people in some way overcome addictions or cease to engage in criminal activities such as drug dealing or prostitution. Of course, the concern being that the activity will just move as opposed to leave a community or leave the NWT. It may move from community to community. So yeah, that's really my question is, has evicting people in other jurisdictions actually worked to reduce the drug use and crime that we're speaking about, or has it simply moved it around? Thank you.
Minister?
Thank you, Madam Chair. Madam Chair, so, I've had this conversation about this many times with the commander of the RCMP, and this activity really is about disrupting the drug trade. Making it as difficult and reducing the profit as much as possible. As far as the statistics question, we don't have that data, or at least I'm not aware if we have collected it, or if any jurisdiction has collected it. But we're certainly able to check and see if we do have it. But I'm not aware of it. Thank you, Madam Chair.
Okay, thank you. MLA Morris, do you have a follow-up?
Yeah, thank you. I mean, that's certainly a bit disappointing. I mean, we've seen scan legislation implemented in other jurisdictions, and it's unfortunate that the data collection has been such that it hasn't been able to show itself as effective yet. And that kind of raises the question for me, why there's a desire to implement it when we have other evidence-based solutions where there is evidence that it reduces drug use, such as poverty reduction, addictions treatment, different kinds of community and individual empowerment. Those are all shown by lots of evidence to reduce these various things. And I think targeted crime enforcement. So enforcement that targets drug dealers that are committing illegal acts. I mean, we have the capacity to do that, and maybe we need to increase the capacity to do it. And I guess that does lead to the next question that I had, and that is, what else is the minister or the government considering bringing forward that would target some of those things like what I was listing, the evidence-based areas to solve the underlying causes of crime such as addiction, poverty, in addition to SCAN? Because I think that SCAN is at best going to be a piece of the puzzle, but I think we all know it's not going to be the only thing that helps solve this. So I'm just curious where we go from here in terms of addressing some of these root causes, just knowing that I think it's quite obvious that just simply evicting a person may not help them overcome an addiction. Addiction can be a very powerful thing. We see people suffering from addictions willing to endure absolutely appalling circumstances in their life in order to feed and continue to stay in the addiction. And so, I think that we need to go further. Thank you.
Minister?
Yeah, thank you, Madam Chair, and thank you for those comments. I think you're absolutely right. I think there's a lot more that we can do. And certainly, I mean, I'll point to a couple of recent meetings I had with Chief Rebuscazo from Det'anchogh shortly a few weeks ago, talking about a community initiative that they're working on to help address some of the challenges within their community, which we're looking at trying to find a way to fit it into a special projects fund. We recently met with Fort Good Hope last week, had very similar conversations about working with the community to find community-specific solutions. I don't think this is a one-size-fits-all approach. I think we need to work very closely with our community governments and look at how each individual community can really set the framework of what works best in their community and the approach they want to take. And then we're here to provide that support, to work with them, to assist them in finding opportunities for funding to support those initiatives. There are a number of program funding pots out there that different programs can fit into. So our staff has been committed to doing that. Looking at the Community Safety Officer Program as another one. We're just doing the final review of that pilot project. We've been sort of pitching that to the communities as we go around as a tool in the toolbox, if you will, to help with that engagement around the community, to identify some of the issues that are happening within the communities. And that's really been quite a message I've heard from the small communities, that they want that sort of presence in the community, someone that can liaise with the RCMP, that could help relay information. So I think that it's a multifaceted, all-of-government approach. So I think housing programs, transitional housing, health and social services. The Salt River First Nation has a wellness program that they're running now to help address some of the addictions issues. So, I think that how we work together with the communities to do that grassroots holistic approach is the way that we're really going to make the big impact in addressing some of the underlying conditions. I mean, ultimately, addressing enforcement is not going to solve the issue. That works on the symptom, right? We need to work together to find the underlying cause and help to resolve all of those impacts that are, generational. Thank you, Madam Chair.
Thank you. MLA Ekele, do you have a question?
Yes, I do, and thank you to the minister for that. It's where we find ourselves in today, because people are, this is kind of similar to the community justice program, where it's not, charges are not laid. Well, they could be eventually, but looking at how people are afraid to say anything because it could be their family member, and so that's what we're you know, could be their family member and there's eviction or things might happen to them. So having said that, and you did mention a little bit about the whole of government approach, I wanted to ask you, what does that look like? Because this is very important for the communities. Communities want safety. They want safety, and in the process, we don't want to hurt our own people. So when you say the whole of government approach, what does that look like? Thank you.
Thank you. Minister?
Thank you, Madam Chair. Madam Chair, when I say whole of government approach, I'm saying that in a very broad context, not necessarily just the GNWT, because I really believe that this involves the community governments as well. You know, the city government, the larger center governments. Like, this needs to be an approach where it's community driven, because really the communities know what the communities need. And we have many tools in our toolboxes, whether that's in housing or in health or in justice. We have a lot of programs. There's a lot of funding available, but we all need to work together to solve this underlying issue. You know, and I encourage the leaders to reach out to us. You know, I mean, I've been asked to go to many communities. If a community asks for me to come and visit and talk about public safety, you know, the commander of the RCMP, Dyson Smith, has said the same thing. If a community asks us to come and visit, we will come and visit. You know, I'll say our visit to Fort Good Hope was very pointed. They were very honest and very passionate, and we really appreciate that. It's not always compliments. You know, they're telling you how it is, and we need to hear that, how it is in the community, because we can't meaningfully contribute to the solution for that community if we don't hear what the problems are in that community. So to hear from a father talking about his adult children, or to hear about an elder that you know, had their home invaded, or another elder where their addicted grandchildren are stealing all of their money on pension day. These are stories that, you know, hit you in the heart, but that's the stuff that we need to hear, that we need to know about, so we can approach the community with solutions. We can work with the community and find ways to help them heal, to help them address their challenges. And it's not a one-size-fits-all. We need to work individually with every community and find a way to get it done. Thank you, Madam Chair.
Emily Akalai, do you have a follow-up question?
Yes, I do. Thank you, Minister, for that. Because we're dealing with rental properties and homeowners renting their places out to, shouldn't there be something in their lease agreement that says, you know, there shall be no illegal activity, or, you know, otherwise you will be evicted? Lease agreements. And the lease agreements needs to be defined clearly to an individual that is renting a place. And people will do what they're going to do anyways, but at some point there needs to be a reiteration of the lease agreement. So say housing or anybody renting out a property, rental owners will do what they're going to do. They have their own rental agreements, but in their rental agreement, there needs to be stated clearly that these kinds of activities are not permitted on this premise because of, well, you know, however. So I guess that's what I was trying to get at too when you talked about the whole of government approach, and to note that health and social services will have safety in place for people that we're dealing with mental, you know, mental issues. There could be some mental instability issues that are happening that that's the reason this is happening. And also, if children get apprehended, there's going to be some things that are going to happen there too. So in the lease agreement, these things need to be defined and stated, and then revisited every once in a while to the tenants to say, remember, we had this conversation before. We need to let you know again. That's so kind of, it's being consistent with the messaging that's getting out there to the people. I don't know if there's any question in there, but the lease agreement needs to be defined, and it needs to be clearly stated to the tenants. Thank you.
Okay, thank you. Minister?
Thank you, Madam Chair. Yeah, I think there were a couple of questions in there. So I think the one is typically a typical lease agreement will have similar, maybe not define illegal activity, but certain activities within most lease agreements that sort of lays out all the parameters. Very hard for a landlord to prove that, and that's why it's in the act. It allows the director, through an investigation, to be able to prove that illegal activity. And, you know, if we look back 15 or 20 years, perhaps the landlord going to a tenant and, you know, saying, you need to stop that or I'm going to kick you out, was a thing. In this world, I think if you look from the level of activity of houses getting shot, houses getting burned, the level of intimidation that is in this world, certainly, you know, people are scared to drop a dime on someone and make a call. I would suggest possibly landlords are equally reluctant to be going and knocking on a known drug dealer's door to say to them that if you don't stop doing this, I'm going to evict you. So, you know, in theory, it's a pretty good theory, but I think in practicality, it's probably somewhat challenging under certain circumstances. Thank you, Madam Chair.
Thank you. MLA Morgan?
Thank you, Madam Chair. So I see in the presentation, it talks about how, like, acknowledging that, you know, the plan is not to put scan officers in every single community in the territory, that would not be feasible. But it talks about how the idea is that you could contract investigators if there was like a surge of complaints or more demand at certain times, and that potentially in smaller communities, if complaints arise, especially if there's a series of them, then maybe you could even hire locally in small communities, hire investigators to do that work sort of on an ad hoc basis. So I appreciate the attempts to try to figure out how to make the resourcing work. I wonder, though, if there will be any due diligence or requirement in the act or regulations that any investigator that's hired, that they can't have sort of a conflict, or, you know, that they have to be impartial. Because, you know, we definitely love the idea of local jobs and hiring local people, but if everybody knows each other locally, and if someone's related to so-and-so, and then you hire them to investigate, there could be a danger there of bias, or they just kind of go along with, well, everybody knows this to be true, so we don't really need to like find evidence because everybody just knows. So how will you get around, if you're hiring people locally to be the investigators under the SCAN Act, how will you get around the challenge of potential bias, or, you know, maybe everybody in the community is out to get somebody or something like that? Thank you, Madam Chair.
Okay. Minister?
Yeah, thank you, Madam Chair. You know, within the Act, it says that to be eligible for appointment under the Act, you must have the prescribed qualification. So I think in this instance, perhaps a good comparison would be a wildlife officer from a small community that is working in their community, where they know everyone, but they've also taken an oath. So, you know, they have the appropriate training, they have the background. If they are in a conflict, then they need to declare that conflict. If it's a family member or whatever reason, then there's an obligation to declare that conflict. So this would be very similar. Thank you, Madam Chair.
Thank you. MLA Morgan, do you have a follow-up question?
Yeah, thank you, Madam Chair. So the one difference, though, that I would see with wildlife officers is, I mean, wildlife officers are employed full-time, I understand it, whereas if we're talking about ad hoc, sort of contracted investigators, they might only be hired or contracted for very short periods of time or you know, as sort of one-offs. So is the plan then to create kind of a cadre of, you know, people that up front you find people in each communities, and each of the communities you train them? Is that the plan to start? Because it sounds, when you use words like ad hoc, that it would just be, oh, if the opportunity arises and now we have a surge of complaints, now we need to find someone locally. You know, they wouldn't have that long background of training and sort of professionalism that we might expect from wildlife officers who are in that position for a long period of time. So I wonder if you can clarify what the plan is there. Thank you.
Thank you. Minister?
Yeah, thank you, Madam Chair. Madam Chair, so this would be, again, a provision within the legislation that would allow for the potential opportunity down the road. But this would ultimately become part of the implementation plan to look at how those resources will be addressed. So that's the director, the number of investigators, what the other tools within that is. But within the Act itself, it gives you the provision to do that. So it would be looked at in regulation as well. Thank you, Madam Chair.
Okay, thank you. I do have one too, as well. Okay, I'm still, you know, it's going back to the public versus private homeowners or private rental, because this bill's applied to them, not to the private homeowners who, you know, we all know who the drug, you know, the drug dealers are and the drug house in the communities. Because this bill doesn't apply, and you said the whole of community approach, and, you know, and for the community to work together. You know, we all love our communities. We love our people, especially the children, which they are the future generations. And the reason why I'm saying this is because, you know, like some of the homeowners, private homeowners are the vulnerable. They're the target by the drug dealers, especially in small communities. And maybe it's in the larger regional center too as well. I'm not too sure, but in the small communities, they're vulnerable. There's a lot of them. And they also get them addicted to the drugs as well. And so for the whole government approach, and I know this was done in my community where some cameras were put on the street lights, and working with other governments and, you know, like with NTPC, well, wherever you know, they provide the services. And community government. So I'm just wondering, in order to work on this legislation, if the minister is working with other government departments to put up cameras, and that was done in my communities, where, I mean, I don't think the community, some of the community members, they don't know where the cameras are, but it's just that that's part of the, you know, keeping our community safe. So I'm just wondering if you're working with NTPC or, yeah, the infrastructure department on improving or installing cameras in most of the communities. Thank you.
Thank you, Madam Chair. Madam Chair, not that I'm aware of, working directly with a government directly around installing cameras. We have had some conversations with different governments around some of the requirements and where you can put cameras and where you can't put cameras. There's been some of those conversations going forward. But as I've indicated to all of the governments that I've met with, happy to assist them, with looking for pots of money or where specific special projects or community projects could fit in with any funding opportunities that we have through the Department of Justice. So always happy to work with the community if it's something that fits in the envelope of what we deliver. Thank you, Madam Chair.
Minister, this is a really important legislation that's before us. But we're gonna, before we end, my colleague over here has a small little question, she said. Okay, go ahead, please.
Thank you so much, Madam Chair. I appreciate it. I'm just thinking pragmatically, and I know there is quite a lot of support to see this bill through in the House. And so I'm looking at both Section 41 in the bill and which is the regulations, and as well as the very last section, which is Section 43, the coming into force. So as members are quite aware, there is a whole host of legislation in the territory that has not yet come into force because of the regulations are not yet in play. I don't necessarily see that happening here, but you spoke a lot earlier about implementation and trying to sort out what the implementation looks like and what the timelines look like. And reading over the regulations section, there's a lot to contemplate there. So what is sort of the department's hope should the bill be passed to see both the act come into force and the regulatory work be completed as well? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I don't actually have a clear answer for that question sitting here today. I think that as we move forward through the three pieces of legislation, and they all kind of work together, civil forfeiture, trespass, and scan. So working through getting the bills passed, and I mean, it would be my preference to prioritize moving, once the three pieces of legislation are passed, would be to continue to leave them on top of the list as the priority to get the regulations and have them come into force. I mean, our issue with drugs and crime in the NWT is not going to go away. It's not going away anytime soon. The RCMP have only so many tools in their toolbox, and I think they've done tremendous work over the last year in disrupting and, impacting crime, and they've had a number of significant arrests and seizures all across the NWT. But that work needs to continue, and we need to make sure that we have the tools that we can provide as a territory available. I think it's important that the work on scan, I think, is really super important because everyone is very, very passionate about it, irregardless of your perspective, which side you sit on, how you look at it. I think it's really important piece of legislation. And I really look forward to the opportunity to see the recommendations from committee. But I think it's something that, in my opinion, will be a valuable tool to assist in the war on drugs and crime. But I'll leave my comments at that. Thank you, Madam Chair.
Okay, thank you. Thank you, Minister, for appearing before the committee. This concludes the public briefing on Bill 49, Safer Communities and Neighborhoods Act. Thank you.